issues that may come up. With respect to 50A, I think you're correct that it is a state law. With respect to Commissioner O'Neill, he has attempted to be more transparent within the bounds of the existing law by attempting to, release body-worn camera footage. That was the subject of litigation. Recently, we had a favorable court decision that permitted the release of body-worn camera footage in the sense that it didn't classify it as 50A personnel records. We also, the Commissioner also tried to release data that would provide greater transparency into our discipline process, that would include having summaries of cases so the reader, the public, would be able to not only see numbers and statistics of how many cases are coming in and what kind of bucket it falls into, but they could also get a feeling of what are the cases about and could compare and contrast cases. That attempt is the subject of current litigation and the subject of a stay. So what we're left with is to be able to be as transparent as possible within the bounds of the law. We're committed to lobbying in furtherance of an amendment to 50A that would offer the protections that I mentioned, because 50A should not be repealed, and I need to say that as clearly as possible, because I think what oftentimes gets conflated is the need for greater transparency into our discipline process with the safeguards that are created by 50A. We can have both. We don't need to throw away the safeguards that are afforded to our officers at the cost of transparency. We could actually amend the law that could give greater insight into discipline records, while at the same time maintaining the purpose of that law, which was to protect officers against harassment. Because at the end, officers testify. There are many folks that are protected by 50A. Many corrections officers, fire department, but police officers are unique in the sense that police officers routinely testify in court as a function of their duty. And what 50A was built around was not to conflate the charges being brought against an individual that's being tried in a criminal case with the harassment of an officer and digging up irrelevant accusations against an officer and diverting the attention of the juries away from the subject of the trial and onto a police officer. So that's what 50A was actually built for, and that part of 50A should remain, as well as the protections against personnel records, that are not connected to discipline at all, the things that just generally aren't of any kind of public interest.
Madam Chair, can I respond as well?
Certainly.
So with regard to 50A, the CCRB has not made a decision to back any particular bill, but it is clear that the current version of Civil Rights Law 50A as it exists is a real impediment to communicating to the community and explaining what exactly is happening in the police disciplinary system. The CCRB is committed to doing everything it can within the law as it stands now to inform people of what's going on in the disciplinary system. And if you look at our quarterly APU reports, you will see that we include summaries of cases in a way that stays within Civil Rights Law 50A, but does explain not only what the CCR believes happened, but if the police commissioner has a difference of opinion, what that opinion was and the reasoning behind it. And with regard to the first part of your question about, Mr. Commissioner, with regard to do we have conversations, yes we do, because as we're very different agencies with very different points of view, but we have to work together in order for the CCRB to do its job of overseeing the actions of the NYPD's members of service. And so while we often communicate in order to explain each other's points of view, there are sometimes just going to be differences that can't be bridged. But we work as hard as we can to explain and explain our point of view and hear from the department their point of view.
And if I might add to Mr. Darsh's comments,
we have conversations that aren't just conversations, but they are constructive conversations for both sides. The department learns from our conversations with the CCRB. We listen to how the CCRB accepts cases, how they analyze cases, how they evaluate and review cases, and where we agree with the CCRB on those components, we act upon that agreement. But where there's a disagreement, rather than just attempt to be heavy-handed and not communicate, we speak back to the CCRB and we explain to them the department's view of the evidence that the CCRB has uncovered or presented. We explain to them the department's interpretation of a legal standard or of a patrol guide provision that might differ from what the CCRB's evaluation was. And in those conversations, we have learned that we can find a middle ground. We can find a concurrence, if you will, on disciplinary issues. And it relates to all four of the CCRB categories: force cases, abuse of authority, discourtesy, and offensive language. And it's through those constructive conversations that the current MOU has proved to be an invaluable template for us working together, for the CCRB working in the trial room on their charges cases, for the department having an obligation pursuant to the Memorandum of Understanding to cooperate and assist the CCRB in those prosecutions. So many of the things that the Charter Revision Committee is discussing are things that exist within the MOU, but they're also things that we're working with the current MOU and actually achieving through great communication and great understanding. So on those points, I think that the current MOU as it exists is a very valuable tool, is a very dynamic resource for both sides to look at, to evaluate, and process disciplinary cases. And to that end, I personally communicate with John Darsh several times a week, probably more times than I'd like to, but the conversations, while we may disagree in points, they're professional, they're respectful, they're informative, they're insightful. John Darsh will offer assistance from the CCRB to the department to understand what the CCRB's vision is, and we also offer assistance to the CCRB in the form of material, in the form of training, in the form of resources that we have to demonstrate our commitment to what the policies of the department are and to make sure that the CCRB is fully informed and aware of them. And it's through those constructive conversations that I think that we've built a relationship that is almost unprecedented in the history of CCRB, with the level of cooperation, the level of collaboration, and the level of discipline that the department imposes in CCRB cases.
Madam Chair, can...
Actually, the next speaker is Mr. Weisbrod, then Ms. Hirsch, then Ms. Camillo, and Mr. Albanese.
I have, first, just a quick clarification, Mr. Darsh, because your statement is sort of awkwardly worded, but the four changes that you mentioned, I just want to clarify, are changes to the charter that would, in the opinion of the CCRB or your view, enhance and strengthen your role rather than diminish your role.
Correct.
Okay. Second, I'm just a little confused. I don't quite understand. I disagree with my colleague, Commissioner Fiala. This is an MOU that's now existed for 6 years, almost 7 years. It hasn't been amended. It has, as Mr. Chernyavsky indicated, spanned 2 mayoral administrations, 3 police commissioners. Why shouldn't it be codified, given the fact that it has stood the test of time? I've spent a lot of time in city government, and 6 years is more than enough time to get it right, and it appears you have gotten it right. So my first question is, why shouldn't it be codified? And my second question is, what do you think of the various citizens' union recommendations regarding the operation of the MOU and its effectiveness in addressing the issues that the MOU was intended to address? And I first start with Mr. Darsh and then Mr. Chernyavsky.
So I agree with Commissioner Richardson in that the MOU is a great template. I just think it is a template for a charter revision, and I think it belongs in the charter.
So you're agreeing that it should be codified?
Correct.
Thank you.
When I first joined the agency around in 2013, I was the deputy chief prosecutor of the APU, and we were trying to hire staff, and it was a real difficulty to get experienced prosecutors to give up their positions to take a risk on something that they saw as not established. So on that level alone, I think it would make sense to put the APU in the charter. But I also think it sends a message to the people of this city that the CCRB's prosecutorial power on discipline cases is an important part of its function and should be permanent.
Mr. Chernyavsky.
Sure. So the police commissioner is given unique authority in the charter. He's in charge of the governance of the police department, the administration of the department, the discipline of the department. And that was done for a reason, and it's an important reason, which is the individual that holds that spot. And if we look back at, I guess, recent history and not so recent history, the individuals that have held that spot have long records of police service. They rose through the ranks of police officer all the way to the highest rank of the civilian rank of police commissioner. These individuals are citizens of New York City. They take a look at discipline through a variety of lenses, not only that of a citizen, but that of as a police officer in every rank, all the way up to their existing rank. At a time where I think the important balance to strike is that, yes, there needs to be confidence with the public in our discipline process. And I think that confidence can be achieved by amendments to 50A and greater transparency, because even the independent commission of respected legal experts have found that the system is a fair system. The only problem is that not too many people know too much about it and can see that it's a fair system. But I think the other point is that police officers have to be comfortable with the system, have to have confidence in the system, and especially at a time when we're implementing neighborhood policing, which is fully implemented across all precincts, police service areas, being expanded into schools, being expanded into the transit system, where police officers are told, don't only respond to radio runs, don't sit in your car and wait till the radio rings and just go respond to a call. They're being told, spend a third of your time off of the radio, go and affirmatively engage with the public. Put yourself out there. I think when officers are given this expanded mission, this unique mission, that we can do because, I think we can do it because we've seen crime drop to record lows, while at the same time enforcement significantly decreased. Summonses are down, arrests are down, and crime continues to go down. So I think we're leveraging those achievements in furtherance of better ties to the community, building trust with the community, and telling our officers, put yourself out there. But at the same time, we need the officers to also have trust in the system. They need to trust that the individual that has this great level of experience, that has been appointed to the title of police commissioner, will exercise those duties unique to the police commissioner, which, in addition to the governance of the whole entire department, also includes the governance and the administration of its discipline system.
Thank you. Allison?
Yes, just as a follow-up to that for Mr. Darsh, we've heard testimony earlier today that suggests that the commissioner should not be the final arbiter of discipline, and I'm wondering if you or the agency have an opinion on that.
It's a very complicated question. There's an intersection of state law and the charter and the administrative code, and it gets to the heart of, as I think it was Mr. Kaur was describing in the last panel, the difference between oversight and employment. But the changes that the CCRB has proposed to the duty to cooperate, I think, would give people knowledge of what's going on in the disciplinary process that would give them more confidence in the system.
And that includes sort of an explanation when the commissioner decreases the disciplinary recommendation?
Correct.
Public explanation. And can I ask Mr. Chernovsky, can you, I guess understanding the limitations that 50A grants, you spoke to this a minute ago, the prior panel spoke to this, the importance of public trust in the system, assuming, Albany is a crazy place. You may or may not be able to accomplish anything, ever. And, it seems like, especially in occurrences when the commissioner either decreases the recommended discipline, or in cases where there is no knowledge of what's going on and families of victims of police brutality have no idea where in the system, where in the process, the disciplinary procedures may be. What do you see as sort of the obligations of the department in terms of, or what kind of proposals would you share for how to better, understanding the limitations of current law, how to better explain the policies, procedures, recommendations, and processes of the department when it comes to issues of discipline and police brutality?
Sure. So I think that what the restrictions of the law create is our inability to give more pointed or specific data. I mean, I think that there have been interpretations of 50A that have dated back the 5 decades, and more recently there have been cases that found even the redaction of certain information does not eviscerate the protections of 50A. I think what we can do is give some level of aggregate data that looks into the process. I think what we can do is explain the process of putting aside numbers, putting aside how many complaints or how many disciplines and what the complaints are for. What is the process? How does it work? I mean, I've talked about it during the discipline hearing before the council. It's part of my longer prepared statement that I cut out of my condensed statement. I think those are steps that we can take. Now, the Commissioner O'Neill has tried to give greater insight, as I mentioned, by giving case summaries and more data than we currently give, and that's been stayed, so that's a subject to litigation. We can't do that. So we're really playing within the margins. We're trying to push, we're trying to go further, but when a case is filed and we're stayed, we know that that's a line that we can't cross. Now, there are certain information, obviously CCRB puts out certain information on their website. We put out certain information on ours. I think the Blue Ribbon Panel certainly made a recommendation that we be more transparent and look at these things. The Commissioner impaneled an implementation panel, so we're looking at that now to see how far we can go. I think in the last week or two, we started posting trial room calendars on our website, something that was a recommendation of the panel that gives greater transparency. I think one of the issues was that attorneys from some of the stakeholders would be seated in the trial room waiting to see if the case they were interested in was coming up. So I think this should resolve that issue. I think, so I guess that's the not so short answer to your question.
Madam Chair,
yeah.
could I respond to that as well? Because I just wanted to explain some of the things the CCRB does to make sure people are informed when they have a complaint that's in our jurisdiction that they've made to us. So every person knows who their investigator is once they make the complaint, and they can reach out and contact them for information on what's going on. We have a website so that if they know their case number, they can look and find out what status their case is in, and if it will tell them to call if they have questions. At the end of a CCRB investigation, the complainant and the member of service are both given written explanations as to what the board's decision was. And then in cases where an allegation of misconduct is substantiated, we give the civilian an explanation as to what the final discipline decision was.
Thank you.
And just to add one point, my colleagues pointed out that one of the recommendations of the Blue Ribbon panel was to appoint a liaison in these situations where the liaison could contact the complainant and give them status updates on the case, and that's certainly something the implementation group is working on.
I have two questions, one short and one possibly longer, but I'll try not to take too much time. This is just that point of information because I don't actually know. Can the CCRB take complaints from witnesses of police misconduct or just from victims of police misconduct?
So that's currently subject of litigation, but currently the CCRB takes complaints from witnesses of misconduct.
Okay. And then from my limited reading, it looks like the concurrency rate, I guess is the technical term, between the CCRB recommendations and the police commissioner's final discipline ruling has dropped considerably. And I wonder if either of you have any explanation or if there's anything the agency, the CCRB, is doing to deal with that issue or why that is.
Actually, thank you. Actually, I think the disciplinary rate for the full year of 2018 has actually gone up. We saw a decline in the concurrency rate between the two agencies in 2017. There had been some adjustments made to the reconsideration process that I think caused that reduction in the concurrence rate. Those changes have been revised, and so for 2018, I think that you'll see that the department imposed discipline in over 90% of the CCRB cases, including 85% of the CCRB's most serious cases, the charges cases. So it's through that, again, that communication, that collaborative effort that we've spoken about to make sure that the department is disciplining its officers properly, which is what the department's interest is, which is what the CCRB's interest is, and I'm not speaking for Mr. Darshey's here, but we do that through our joint communication. So yes, there was a dip downward in the concurrency rate, but we've seen that go up for full year 2018, and I expect that to improve for this year as well.
I think a lot of the discrepancy comes between using our discipline rates and the concurrence rate. So the discipline rate measures if the CCRB recommends discipline and the department imposes discipline. The concurrence rate is lower, which is when the CCRB makes a recommendation, the department imposes exactly that recommendation. So in a APU case where a member of service has had 5 allegations of misconduct on their charges, and the CCRB makes a recommendation based on the guilt of the member of service to all 5 specifications, and then not all 5 specifications are guilty, and either the hearing officer recommends less than what the CCRB's original recommendation is, and then the police commissioner imposes less than what the CCRB recommended, that shows up as less than concurrence.
Thank you.
Thank you. Ms. Camillo?
Thank you very much for the testimony. My question is directed to Mr. Darsh. So you focused your testimony on 2 recommendations, but I was hoping you could expand on the other 2 that you didn't talk about. So the subpoena signatory power, as well as the duty to cooperate.
With regard to the subpoena power, it seems silly, but days matter. In New York City, many of the locations that record video copy over it after several days. So if the CCRB needs to investigate or gets a case, drafts a subpoena, we have to take it uptown to where the current chair is working, because the board is part-time, and then he signs it, and then we have to get someone to bring it back, and then we can serve the subpoena. And if you lose 2 or 3 days, you might have lost the evidence. So it is actually very important to be able to designate a staff member to sign those subpoenas so that we don't lose valuable evidence that is helpful in having the CCRB make a determination. The CCRB is committed to fair and impartial investigations, and we need evidence for that. And it's important for us to get that evidence, and the video is a very important part of that function, and the presence of body-worn camera footage is helpful in that part, but also just video that's being used by different locations to surveillance video. For us to get that video is very important.
Thank you. Commissioner Albanese.
As one of the panelists pointed out, I think all of you agree that a disciplinary system has to be fair and transparent. The public has to be comfortable with it, as well as police officers. Otherwise, it's just not going to work. We have work to do in order to make sure that it does work. I just want to clarify something. 80% of the complaints are either unsubstantiated or false, correct, at CCRB? About 80%?
No. I don't believe that's
What's the number, do you know?
So approximately half of the complaints in our jurisdiction are not fully investigated. Of the cases that are fully, and that's for a variety of reasons. Sometimes someone has pending litigation, whether it's a civil suit or a criminal case against them that they don't want to give a statement. So the case is closed without having a full investigation. Sometimes we're unable to find them to get a full statement from them. Madam Chair, would you mind if I finish answering? Of the cases that we do fully investigate, approximately 20% are substantiated. I should know the exact number of exonerations, unfounded, but there's also, I'd say approximately half of the cases are unsubstantiated.
Let me get the essence of my question. The unsubstantiated complaints or false complaints.
I'm not sure that unsubstantiated means false.
Yeah.
Unsubstantiated or false.
Okay.
Or false. No, I didn't say that. Is it your proposal to publish the names of the officers when complaints are unsubstantiated?
I don't think that was proposed, but if...
But that's not something that you're considering?
So not in these 4 proposals, no. And it's something that if Civil Rights Law 50A were to change, it's something that we could consider, but certainly, members of service who have either had their allegations exonerated, which means that the conduct that was complained about occurred. So the CCRB was able to determine that the civilian made a complaint and what they complained about happened, but the officer did not commit misconduct when it happened. That's not a false complaint. If the CCRB did an investigation and was unable to determine by a preponderance of the evidence what happened, that's an unsubstantiated complaint. That doesn't mean it didn't happen. So it's a very small number of cases that are false complaints.
My point is that a police officer's career could be, if that information was public, an officer's career could be derailed or sidetracked if that officer.
Please, we agreed that was not going to happen.
If that officer had say 3 or 4 unsubstantiated complaints. That's why I'm asking the question, is that one of the things you're considering, publishing the names of officers who've had unsubstantiated complaints?
So I don't think that would actually derail someone's career, and we inform the department when what happens in those cases. So
So are you planning to publish the names of officers?
No, sir. No,
Okay.
Mr. Commissioner.
Thank you.
Okay, I've got a question now, a series of questions. And the first, Ms. Conti Court,
Cook.
who spoke earlier, spoke about the problem of the law department representing both you and the police department and basically everybody else who's involved in the process except for the lawyer for the complainant. Do you see that as a problem also?
So I'm aware that some people consider that a problem. We monitor the situations that come up to look for active conflict between that would prevent the law department from representing the CCRB, and in those cases, I would go to the board and request permission to retain outside counsel.
And in your experience, how many times has that happened?
We have not done that.
Excuse me?
We have not done that.
So is that because you don't consider any of the cases that have come before you to have had that issue because the board did not approve outside counsel, or this just isn't an issue in your mind?
So my understanding of the case law surrounding this issue is that there needs to be an active conflict and active litigation. And so far, I, as executive director, haven't been confronted with an issue like that where I've gone to the board.
Do you think there's a smaller issue that may not be active, but that the law department is speaking on behalf of more than one client whose interests may not be perfectly aligned?
That's possible.
Anyone else? Oh, no, I was just asking. And my second question, several of the first panel raised the issue of other kinds of officers who may be subject to disciplinary actions, peace officers, school safety officers, and that they are not under the umbrella of CCRB. Do you think it would be a desirable thing to have them under the CCRB?
So if the city were to change the charter to add peace officers and school safety agents to our jurisdiction, it would be an extremely difficult expansion. Number one, I think just school safety agents are another 5,000 school safety agents. So how would we have the capacity to take on that added responsibility? It's not something that I would just take on. But it's more than just the numbers. It's also my investigators are trained and experienced in dealing with the patrol guy that members of the NYPD are responsible for abiding by. I don't know what school safety agents or HRA peace officers, how they're trained, what their standard they're held to. It would be, I'm not saying we couldn't do it, but it's not something that if in November when the voters vote on charter revision, if it was enacted, it's not something that we could do quickly. It would be an intensive process for us to get up and running and resource intensive.
I don't think it's good for the schools either, right, to have that. You know, I was involved in school safety officers for over a decade, and I just don't see. I understand the need for monitoring them, but I just don't think that that's the right basket to put.
When PD was in the schools, though, did complaints against school safety officers who were members of PD fall within the CCRB jurisdiction?
So school safety agents were never in the CCRB's jurisdiction, but police officers, sworn members of service, even when they go into a school, are in our jurisdiction.
Thank you. The next person is Mr. Karras.
I just was curious as to what effect the APU prosecuted cases since the 2012 MOU has had on the discipline and the concurrence rate.
I'm sorry. I'm sorry. Can you repeat your question, please?
What effect the APU that was required by the 2012 MOU has had on the discipline and the concurrence rate? I mean, has there been a correlation? Has it been negative, positive?
Do you mind if I answer?
Please.
So in the year and a half before the MOU went into effect, which is before Deputy Commissioner Richardson was at the department, there were no trials in cases that had been referred by the CCRB. Just having the APU has resulted in 374 public trials that people can attend and see. So just from that alone, the amount of visibility into the discipline process because of the APU's presence is dramatic.
So let me ask the police department. So you don't want the APU codified, so you would be okay going back to a situation where if I don't mean you, this police commissioner, but where a future police commissioner sort of threw out the MOU and we went back to no trials?
No, I don't think that at all. I think that we have shown, first, the APU and the MOU was voluntarily entered into. So this is something that the police department saw value in. We, as we do with many of the programs, initiatives that we do, we always reevaluate, reassess, and see and try to find ways to improve. That improvement as it related to discipline in 2012 was giving CCRB prosecutorial jurisdiction over cases pursuant to the MOU. Now that MOU has survived and been built on and improved. So I would not say that we want to go back to
No, I don't mean you.
No, I understand. But I'm speaking on behalf of the department.
The mayor, another police commissioner,
right,
could want to go back to a situation where there are no trials, and not codifying the MOU would give them that opportunity.
Well, I think that's a bit of a misnomer, the term no trials. There were trials prior to the creation of the MOU and the creation of the Administrative Prosecution Unit. It's just that those cases were tried by department trial lawyers, but the cases were tried in the same courtrooms that the CCRB appears in and tries cases. So the cases were tried, they just weren't tried by the CCRB.
But were they CCRB cases that were getting tried? I don't believe so.
CCRB cases were tried as well. If a CCRB case that was substantiated was brought to a position where it was going to be where it was trial ready and it needed to go to trial, those cases would go to trial. So it wasn't that no cases were tried. It's just before the APU, the CCRB's prosecutors weren't the prosecuting attorneys.
How, I guess, I'm then
I think we agree to disagree on that.
I'd like.
Well, I think but to your larger point about future administrations, I guess. Coming before the council and testifying on a regular basis, I think at last count 4 or 5 times a month, I can tell you that if a program, an initiative such as this were to go away, there would be a lot of answering to be done to the 51 members of the council. We're routinely subjected to oversight, whether it be by the city council. We have an inspector general that does oversight of federal monitor, and on. The Commission to Combat Police Corruption. So we're very accountable, and we're held to account, and we're called to hearings where we need to explain our decisions. And in the scenario that you raise, that having a situation where some future police commissioner is going to say, okay, no more APU, and we're not going to prosecute CCRB cases either. I think there would be a lot of explaining that needs to be done, and I can't envision that such a scenario would ever happen.
Paula, you're next, and then Allison.
This is for Deputy Commissioner Richardson. I have noticed that you two don't agree, and that the four proposals you don't agree with and CCRB does agree with. But one of them I want to poke at a little bit, which has to do with the police commissioner documenting the reasons for his decision. In the independent review panel, the recommendation was to go to a decision matrix and to use that to explain decisions. Is that going to be implemented?
First of all, thank you for your question. The Blue Ribbon panel suggested that, one, the police commissioner detail more specifically why he deviated from a disciplinary penalty. The police commissioner has committed to that recommendation from the Blue Ribbon panel and has already begun the process of formalizing informational memoranda of why the police commissioner made the decision that he made in a particular case. But with respect to the disciplinary matrix, the department had been considering that for some time. The recommendation of the Blue Ribbon panel just strengthens the resolve to review the disciplinary matrix. So that is currently under review by the implementation committee. And we've actually had conversations with the CCRB where we've committed to including them in the conversations about creating and building a disciplinary matrix that we would both share and utilize. And I do agree that if we had such a matrix in place, it could assist in the disciplinary concurrence rate, but a matrix is not an absolute because there are always going to be variables in each and every case involving each and every officer that have to be considered, both in the department cases and in CCRB cases. So we're making sure that we create a matrix, a system that takes into account the need for standardization, yet maintains the ability to have flexibility.
So to some degree, you do agree with the proposal to strengthen the documentation?
Yes, I do.
Exactly. Okay. And then the other one is a totally different question. And that is that you've talked to the proposals that you support or don't support. Is there anything that NYPD would like in the charter? For example, neighborhood policing. Is there any issues that are important that you think should be in the charter?
That's a good question. I think, I think generally speaking, I'm not going to be able to give you exact proposals, but I think anything that strengthens our ability, generally speaking, to provide better police services, to
build trust,
to offer greater transparency. And I think just to the transparency point, yes, we're working towards an amendment to 50A, but I would argue, I think most would agree that we're probably the most transparent we've ever been. I think we've collaborated with council on, I would say, over 30 or so transparency bills where we put data up. We've put our patrol guide online. We self-initiate reporting, CompStat 2.0. If you simply just go to our website, and you'll see a tremendous amount of data, a treasure trove of data that could enable individuals, the public, academics, to crunch numbers, determine patterns. We put most of our data on machine-readable format, so making it easier for folks to digest. So, yeah, the non-specific answer.
Well, I think police accountability does have an underlying point on trust, so maybe you do want to think about if there's anything. Thank you.
Thank you.
Commissioner Hirsch?
This question is for Mr. Darsh. On the first panel in particular, we heard a lot about the makeup of the CCRB. I think in the limited research I've done, many other cities, their independent review board does not have any appointees, for instance, made by the police department or the commissioner. There were also one panelist spoke about the fact that the youth she works with doesn't look at the either members of it wasn't clear whether it's the members of the board or the staff and see them as folks that they feel comfortable and trusting in submitting their complaints. And so I was wondering whether you have any thoughts on whether the current makeup of the CCRB works or what the ideal makeup of the CCRB would be.
So I think, and I believe the board is committed to making sure the board and the staff of the CCRB reflect the diversity of this city. And the CCRB has hired a recruiter to make sure that when we are bringing on investigative staff, that we are trying to get not just the best people, but the best people who also reflect this city. And I'm confident that we are making strides to doing that. It is something that we are committed to, that the board has charged me with doing, and I take very seriously.
And in terms of the makeup of who gets to appoint and the makeup of the appointees on the board, do you have a position or that, or is that too fraught for you in your position, which is fair?
So I've seen some of the proposals, and I think they go towards how the board functions at its core. So most cases are heard by panels of 3 people. One city council designee, one mayoral designee, and one police commissioner designee. If there's a different type of designee added to the mix, it would make for a 4-person panel, which could result in ties, which is something that we try and avoid. And it also will make it much more harder to schedule panels. And it is a real priority for the agency to do things as fast as possible, and it's a real struggle. And making that process more complicated, if that happens, we'll work with it. But I just urge you all to take into account how we actually hear cases when you are working on who designates things.
Thank you.
Thank you very much.
Madam Chair, Commissioner Camillo had asked a question earlier, and I only answered one part of it, and I want to apologize and see if there's a chance for me to answer it fully.
Okay.
With regard to the 1%, there are sometimes things that happen in the NYPD in their budget over the course of a year, decisions that they make that have a real impact on the CCRB. They require us to have to change how we train. They require us to change our technology. And while I understand what Mr. Chernovsky, Executive Director Chernovsky, said about how every agency should have to justify its own needs on its own terms, it is very tough to do oversight over the largest police force in the country when you're playing catch-up.
Thank you very much. Seeing no further questions, I want to thank all of you. And I want to thank all of the people in the audience, all of the participants who have been here and been a part of this hearing. I appreciate your time and your interest. I appreciate the courtesy that you have shown us, and I hope you feel that we have shown you. And our next forum will be on Monday, March 11th at 6 p.m. at the Borough of Manhattan Community College, and that will be on finance and budget. So I thank you very much, and do I have a motion to hit the gavel again? Is there a second? Any discussion? All in favor? Opposed? The meeting's adjourned. No, they're not.
I can.
One of they they have the school safety officers. There was a move.
It was fun. We will never do that.
Fun.